Okay, here we go. Meow away wolf. Hey, how are you? If I remember correctly, did you say you were in Dallas? Trying to remember with the chat. I'm going to give a few more people an opportunity to show up. Look like we're at 23 viewers now. As usual, before I start, I like to just check in and see where everyone is coming from, where they're viewing from today. You obviously came here to waste my time. That is my favorite phrase. You want to know where I got that from? My mom, ever since I was growing up as a little girl, she used to say that you obviously came here to waste my time. So it just kind of stuck with me, I guess. Hello, Cloud Martinez. Sacramento. Okay, here we go. Minneapolis, Minnesota, Louisiana, Southern California, Meow Away Wolf, Dallas. I knew it. I knew you were in Dallas. Montgomery, Alabama. Okay, well, thank you all for tuning in. Again, the information that I'm giving. Hello, Maisha Freeman from Atlanta. DeAndre Brothers Career Day. Thank you for coming. Absolutely. I enjoy Career Day. So today, you guys, I attended Career Day at Kennemer Middle School, which is located here in Dallas. And it was a blast talking to the students. They really, really were giving me feedback, asking great questions. I love doing Career Day. From Detroit, too. How are you? All right, guys. So we're going to go ahead and jump in. Remember, we've been doing our series about the temporary orders hearings. And today we're going to talk about do's and don'ts. Remember, the information that I am providing regarding the temporary orders hearings specifically it pertains to Texas law. So if you hear something that may sound familiar in your jurisdiction, make sure you consult an attorney within your jurisdiction. However, today's conversation, I think that these do's and don'ts that I'm getting ready to say may be good for jurisdictions across the board. Okay. So let's start with the do's. When you're going to your temporary orders hearings, some things that you need to do. Number one, before you even step foot in that courtroom, make sure you're dressed appropriately. I've seen people come to court in house shoes. I've seen people come to court with hair bonnets on, all that kind of stuff. Don't do that. That is not appropriate for court. If you wouldn't show up to work like that in a professional setting, don't wear it to court. Okay. Now, that's not to say that you need to be in a three-piece suit or anything like that. However, you do need to make sure that you're dressed appropriately. What do I mean by appropriately? Because some people's interpretation of appropriate varies, right? So when I say appropriate, if you're going to have a t-shirt, make sure it doesn't have anything vulgar or obscene on it. If you may have to take a drug test in court because the child's father or the child's mom says that you use marijuana around the child, it's not a good idea to wear a t-shirt that has a marijuana leaf on it. Okay. It's not going to be a good idea to wear socks that has a marijuana leaf on it. Stuff like that. That's what I mean by appropriate. You can wear a graphic tee, but just make sure you don't have anything, like I said, vulgar, obscene. For ladies, make sure that it's not a cutoff or a mid drift shirt where it's showing your cleavage or it's showing your stomach or your back tattoo. I mean, that tattoo looks nice, sis, but we don't need to see it in the courtroom. Okay. So just make sure you're not wearing anything like that that's revealing too much. Same thing with jeans. You can wear jeans, just stay away from the jeans that have frays, the holes and all of that. It looks good if you're going to brunch or you're going to be hanging out with your homeboys or your homegirls away from court, right? But in court, that's not appropriate attire to wear to court. Okay. So those are just a few things when I talk about dressing appropriately. The next thing I want to make sure that you do is tell the truth. Okay. When you raise your hand, your right hand, and you swear to tell the truth, the whole truth, and nothing but the truth, do just that. Tell the truth. Judges are not dumb. They are human, just like we are. They have been in situations just like we have. They know when you're lying. When your story doesn't add up and it's not making sense, it's obvious that you're not being truthful. Be truthful, because I can assure you, if you're not being truthful, one way or the other, it is going to come out. It may not come out with that first lie that you told, but that second part is not going to make sense. I've seen it happen a number of times. Hey, wait a minute. Didn't you just say this? Well, yeah, I did just say that, but that doesn't make sense because it doesn't line up with that. You see what I'm saying? When a judge is asking you that, that means that they're trying to get the truth about what you're saying. Now, the other attorney may be trying to catch you up in a lie. The judge is not necessarily trying to do that. They're refereeing, they're just listening to the facts. But if they specifically say that, that means that they're hearing something that doesn't make sense, because 9 times out of 10 it's not truthful. So make sure you're being honest. The next thing I want to tell you, make sure you focus your issues. If you're going to be representing yourself and you are seeking to get sole custody, or you're seeking to get an increase in child support, or you're the person paying child support seeking to get a decrease in child support, make sure your issues are focused specifically to what it is you're going to be asking for in court. Remember, I told you from the very beginning, temporary orders hearings in Texas, 20 minutes aside. That means 20 minutes for your side, 20 minutes for the other side. That means you have 20 minutes to tell the judge why you're there, put in any evidence you want to show, get any witnesses in that you want to talk to, all that kind of stuff. So you have to make sure that you are focusing these issues, okay? The next thing you want to do is have what's called a summary of requested relief. I'll repeat that, a summary of requested relief. Well, Vonda, what is a summary of requested relief? A summary of requested relief is where you are telling the judge what you want in court. Remember, this is nothing, guys, that has to be fancy. You don't have to, draft it out on a what do you call it? A Microsoft Word document. This can be something that's handwritten, okay? But you do need to make sure that you're telling the judge exactly what you want. What I would recommend you do is, if you are going to handwrite, or if you're going to use a Microsoft Word document, put sections, right? What do I mean by sections? So the beginning, at the top, right, you want to tell the judge exactly what this document is. If you're the petitioner or respondent, this is petitioner's summary of requested relief. Respondent summary of requested relief. That should be at the top of your document. So you're already letting the judge know what it is that you're referencing in that document, okay? Underneath that, conservatorship. If you all are tuning in for the first time, we talked about conservatorship on an earlier episode. Put what type of conservatorship you're looking for. Are you looking for sole custody? Are you looking for you guys to be joint managing conservators, but you determine where the child lives primarily? Write that on there. So under conservatorship, you put a little sentence that tell the judge what you want. Judge, I'm requesting that I have sole custody of the child, period. You're done with conservatorship. Underneath conservatorship, possession and access. If you're asking for the child to stay with you primarily, or you want sole custody, the non-custodial parent has to have some sort of possession and access. Write another section and underline these sections. So conservatorship, bold, underline. Possession and access, bold, underline. Under possession and access, put your one sentence. Judge, I'm asking that the other parent have visitation as follows, period. Okay? That's what you need to do on that. The next thing, child support. If you're asking to be the parent that the child is living with, you obviously want the other parent to pay child support. Child support, bold, underline. I'm asking that the other parent pays child support. You don't have to be any more specific than that. Now, me, I would say that they pay within guideline, right? But I'm the professional. I know these things. These are the books I read to know that exact legal knowledge, that exact legal term, right? You don't have to do that. I want the other parent to pay child support. The judge that will let them know you're looking for child support within guidelines, right? Um, and what was I getting ready to say? Oh, I looked at a comment. Vonda, look, I love you, but you really came here to waste my time. Oh, that is funny. Okay, so after child support, what's the next thing you're asking the court to do? Are you looking for supervised visits at a supervision facility? If you are, write that. If you are going through a divorce and you're looking for certain property to be awarded to a certain person, write that down. But just make sure that it is neat and it makes sense. Okay. I hope that made sense what I just said. Make sure you have a summary of requested relief. That is extremely important. It tells the judge like a quick synopsis of what it is that you're asking for in court. You want to do that. All right. The next thing you want to do is to make sure you are prepared for court. What do I mean by that? In addition to focusing your issues, make sure that you have prepped your witnesses. If you're going to have a police officer testify, there's a certain way that you have to get testimony in through that police officer. And we're going to cover all that. That's called land the proper predicate. And you will also hear it people refer to it as land the foundation. You can't just put them on the witness stand and say, tell me what you saw on November the 18th, 2021 at 2 o'clock p.m. That's not how it works in court. You literally have to lay the foundation. I'm going to tell you how to do that. So you have to make sure that in your prep of your witnesses, especially if they're going to be professionals, you have to make sure that they are prepped ahead of time. In addition to making sure that you have questions that you're going to be asking them, make sure you've actually had a conversation with them. Don't just subpoena someone to come to court and the day of, while you're in court, is the first time you're talking to them. Why is that problematic? It is problematic because you don't know what they're going to say. At least if you talk to them ahead of time, you have an idea of what it is they're going to say. Don't do that. It could be detrimental to your case. So, in prepping your witnesses, make sure you know exactly what they're going to say. Something else that I wanted to tell you all too is stay on point. What do I mean by that? Stay on point. Know the difference between factual information and legal information. Okay. The law, depending on the facts, it influenced the law, right? So a situation, a case can go one way depending on what facts are stated. It influences or triggers this part of the law. But you have to know the difference. When you're in court, it's not the opportunity to slander the other side. That is not your opportunity to air out their dirty laundry and try to embarrass them and make them look bad. That is not the time to do that. You want to use the facts that are going to influence what it is you're asking the court to do, right? So again, I'll use the example of full custody. If you're asking for full custody, you need to focus on facts that are going to be relevant to why that other parent is unfit for full custody. Mom or dad having a girlfriend or a boyfriend that you don't like because they look at you funny, or when you've exchanged the child, they don't speak to you or something like that. That is not relevant to whether or not you want sole custody. Is it relevant in terms of communication that you've had with the other person about their girlfriend or their boyfriend and interactions? It may be relevant to that, but it has no bearing whatsoever on the sole custody aspect. So you don't want to spend a lot of time on that. Okay. So make sure you know the difference between factual and legal evidence that you're going to be given, and you stay on point with whatever it is. The more facts you give to try to embarrass somebody is going to do two things. Number one, is going to waste your time. Remember, 20 minutes. You don't have a whole lot of time to get out of there and to get in there and be talking about this, and this. You know the facts better than anybody, so we know you know everything that has occurred. But no, that is not what you're there for. Narrow your facts, okay? The second thing it does, it has no impact on the judge's decision. The judge may sit there and listen to you for 20 minutes, but guess what? When your time runs out, you don't usually get any extra time. And some judges are nice enough to give you extra time, but if they do, they only give you a minute or two. That's it. And you have 15 minutes worth of information that you need them to hear. So make sure you're staying on point. It is very, very important that you do that. Something else I want to make sure that you all do. So there's a difference in questioning a witness. You have direct examination and cross examination. Very different things, very different techniques. So any one of your witnesses that you're going to be presenting in what's called your case in chief. Case in chief is your turn to put on your case, your evidence, your witnesses, whatever the case may be. Okay. That is your opportunity to bring on your case. All right. So anyone that you're going to be questioning in your case in chief are going to be under direct examination. Let me give you an example of what I mean about direct examination. You're giving your witness the opportunity to tell their story. So whatever it is you're trying to pull out of them, whatever information you need them to articulate, you're trying to get that out through the judge. So the best way to ask those questions under direct examination is to keep the questions open-ended. Vonda, what do you mean by open-ended? Who, what, when, where, why, how, please explain, tell me, describe. Literally, when I'm preparing my cases and I'm setting up for my direct examination, whichever person I'm going to be talking to, I write in big letters who, what, when, where, why, how, tell me, please describe, explain. I put that at the top because it reminds me I'm under direct examination. Because if you don't ask an open-ended question, right, the other side can then object to leading. You cannot lead your witness on direct. Leading means you're giving them the answer. You're telling them what to say. You cannot do that on direct examination. You can do it on cross examination because remember, I told you two totally different techniques. So lead on cross, not on direct. So make sure you guys understand that if you're going to be asking a police officer, the child's counselor, the neighbor next door, even your mom, if you're going to have your parent or uncle, anybody who's going to be your witness on the direct examination, who, what, when, where, why, and so forth, open-ended, okay? Cross-examination is a little different. You can lead on cross. If it's the other person's side and you're trying to catch them in a lie or you're trying to prove a point, answer the question for them on cross, right? It's true that you went to that bar on November the 18th, 2021. You're limiting their answer to yes or no. On direct, you're leaving it open-ended so they get an opportunity to explain. Cross-examination, you're answering the question for them, yes or no. Because if they don't answer yes or no, then you can object to them being what's called non-responsive, which means that they haven't responded and answered your question. 9 times out of 10, the judge is going to do what's called sustain, which means that the judge, anytime a judge you hear sustain, that means that the judge agrees with the objection that was made by the person who made it. If you ever hear them say overrule, that means they don't agree with your objection, and whatever answer that the witness was given, they can continue answering that question. When it's sustained, you can't answer that question. You have to answer the question that was originally asked. Okay. But we'll go over objections and all that kind of stuff at a later date. But today, I just want to make sure you guys understand when you're in a temporary orders hearing, you have direct examination, cross examination, totally different. Know the difference. Because when you're preparing your questions, it is imperative that you are writing them in such a way that you're comfortable with having a conversation. Because when those objections start flying, I'm a attorney and I'm the professional. It even throws me off sometimes. If somebody objects and I'm in the middle of something, it throws you off. But if you've already prepared your questions in a way that you're less likely to get objections, your direct examination just flows. Okay. So those are the do's that I wanted to cover. Now the big one, the don'ts. All right. We already went over well, I kind of slid into it a little bit when I was talking about dressing appropriately, but just for totality, um I'm going to address these things too when it comes to dress. Again, don't wear house shoes. That's not appropriate. House shoes, within the name, it tells you how they're supposed to be worn in the house. Okay. Do not wear a hair bonnet. Do not do that. I see it done all the time. People do it not only in person, but even on Zoom. Don't do that. If you're on Zoom court, actually get out of the bed. Don't still be laying down on your pillow or you on the couch like this, like you're not bothered and not interested in what's going on with court. You're watching something else or doing something else. Don't do that. Okay. Please do not wear your pajamas. Yes, people do that. Do not wear your pajamas to court. Is not professional at all. Um, do not bring your new boo to court. Do not do that. If you're going through a divorce, there is no reason you should have a new girlfriend or a new boyfriend in the courtroom. Even if you have one, out of sight, out of mind, they do not need to be brought into court. Why am I telling you do not bring your new boyfriend or your new booze to court? Because if they are sitting in that courtroom, guess what the other side can do? They can call them as a witness. And could you imagine a divorce case where one spouse is alleging um, infidelity, and then you bring in the person that you allegedly cheated with, and they call them as a witness and put them on the witness stand? Yeah, that's not going to be a good look. Okay, so leave your new booze at home. All right. Another reason you want to leave your new booze at home is because family courts have the most fights. I don't know about in other jurisdictions, but in Dallas County, the family courts, they fight. And when I say fight, I'm not talking about just bickering, which y'all see on my show, where I let them go back and forth. That's to add to the drama. In court, people do that, but usually you'll see a judge kind of cut it off, right? They may let it go a little bit, but they cut it off. But people actually fight, like physically fight. Leave your new booze at home. I'll never forget, I was walking into the courthouse back in 2019. I had just given birth to my daughter, and literally two women ran down the hallway, met each other right in front of me, and started duking it out right in the middle of the hallway because it was a divorce. Allegedly, husband had cheated with this new woman that he brought to court, and y'all, it was a bad, bad situation. People got arrested. So obviously that delayed their case, the real reason they needed to be in court. So please don't do that. Don't fight. Don't fight verbally, and definitely do not fight physically. Another thing, when you're on Zoom, because we are still Zooming in court right now, do not drive while you're on Zoom. That is extremely dangerous. Most judges will stop the hearing or not even start it to give you the opportunity to pull over. Can you Zoom from your car? Absolutely. But you should not be actually driving. Okay. It's a safety thing. Don't put on makeup while you're on Zoom. I've seen people do that. Do not do that. It is very distracting and it really defeats the purpose of the reason that you're there. Okay. And although you're on Zoom, just remember the same rules apply as if you were in a courtroom in person. Same rules apply, same standard. You got to have that proper etiquette, okay? That's all I have so far on the do's and don'ts. Those are, I mean, I'm pretty sure there are a lot of them out there, but these are the ones in particular that I see that are the most problematic, especially on the don'ts. And on the do's, a lot of people come to court, they have good facts, they have a good case, but they don't necessarily know how to present it, and they don't have everything that they need in order to present their case. So just make sure overall that you're prepared for this hearing. Again, I cannot reiterate it enough. Temporary orders hearings in Texas usually are 20 minutes per side. 20 minutes to get in everything. So make sure you are prepared when you go to court. Okay. That's all I have. And I mean, I try to go up and through the 30-minute mark, but that's all I have in terms of that for today. So I will entertain any questions or anything that you all may have. Let's see. Hello from Illinois. Good morning. Good morning. Oh, where are you at? Okay. I want to know who that is saying good morning because we're in the afternoon here in Dallas. Monique Jefferson, we love you in the DMV. Thank you so much. I love you all back. Precious Loves, I love you all back. Cindy Martinez, hi from El Paso, Texas. I love your show. Thank you so much for tuning in. You all are the success of the show. You know, without you all tuning in, giving us your comments, your feedback, everything like that, the show would not be as successful. So thank you all so much. Hello, Baltimore, Maryland. Hello. Is it Chevelle Solomon? How are you? Okay, Mind of Roddy. Do you call out someone's dress code or is it ignored and become a problem later? This is a great question. Before my clients, before they go to court, I remind them of how they should dress. Again, I don't say you need on a three-piece suit or anything like that. Matter of fact, I don't even mention a suit. I'm just like, if you have a nice polo shirt, you have a nice button down or something like that, wear it. You can wear jeans because court is, I don't want to say it's casual in the sense that it's lax. It's more like a business casual. If all you have is a graphic tee, because there are a number of indigent people that come to court and that's all you have, that's fine. Just try to wear something that's not obscene or doesn't contain any obscenity or vulgarity on it. So thank you for that question. And another reason why I tell people to make sure they dress appropriately, because again, you have to remember everybody in the courtroom are human. These are not robots. You don't want somebody to prejudge you. As much as we want our judges to be fair and unbiased, the truth of the matter is, if one is showing some bias and it's based on what people wear, then you may be in trouble in their ruling. They may not rule in your favor, or they may rule in your favor, just be really, really mean and ugly to you while you're in there. So to keep that from happening, just do your part and dress the part. What happens when a mother hasn't submitted financial affidavit when the judge ordered it 4 times and keeps forwarding court dates? From Christina. Thank you for your question. I know here in Texas, if you have not provided a financial document, the court can go based off testimony that is received from the other side, as well as the Attorney General's office if they have financial information on that person. And they can base your child support off of that. So that's how that will be handled. Thank you again for your question. We have someone else in here from Illinois, Brittany Robinson. Thank you for coming. What made you start the show? What made me start the show is there were a number of people I went to school with asking me questions about child support and they needed to get back in court and everything like that. So I was like, okay, I cannot answer every single person's message individually. It was becoming overwhelming. Like I literally was getting 30 to 40 messages a day. So the way that I thought I could reach people on a massive scale to educate them about the child support laws in Texas, because I see that a lot of people had questions about it, I decided to start the show Support Court with Judge Vonda B. Obviously, I wanted to have an entertainment segment to it because it's TV. You're not going to watch anything boring on TV. If you think about some of your favorite shows, you don't watch that show over and over. If you wouldn't watch it if it were boring. So it had to have some entertainment piece to keep people's attention. But the most important part of that show is the education. So I'm big on education. I believe that people should know their rights. I believe that if people know their rights, it keeps the playing field level. So if you know what you're up against, you know what it is that you have to present, it gives you a better opportunity to defend yourself when you have to go in court. So thank you, Meow Away Wolf, for your question. One, Barnett said, dress like you left church. I mean, that's a good point. You know, if all else fails, default to dress like you just left court. I like that. Thank you, Juan. Anthony, Judge, my first time. Is a judge allowed to prompt or litigate for a pro se litigant? Mind you, we are both pro se. No, they are not allowed to do that. Now, Have I seen judges do that? Yes. Is it wrong? Absolutely. But it does happen. Is it supposed to happen? No. Um, let me see. They take me for a modification. How can I ask the judge for insurance credit, or can I? This is a great question. You can always ask for, when you say credit, I'm assuming you're saying that you can carry the child on health insurance and get a credit for it or something like that. You can always ask that. And if I'm not addressing your question appropriately, I think it's Nano's Bullies, Texas. Please retype it in the chat. I just want to make sure that I am getting your question. Taylor M, thank you so much for the super chat. Remember, guys, the super chat feature is on. That's where you can participate and have your comment highlighted. That also ensures that I don't miss it. I can see your comment clearly. Any advice for custodial parents trying to serve non-custodial parent on a federal base or shipyard? This is an excellent question. Yes, Taylor, my advice would be to find out who their direct commander is. Find out who that person is and speak with them, and then they will be able to handle it from there. The military is a little different. When you're dealing with anything with the federal government, it's a little different. Even if you were trying to enter a federal building to serve someone, it's a little different. The easiest thing to do is to go through their direct commanding officer. So that is an excellent question. Thank you for that question. Let's see. I have served in jury duty before, specifically for jury trials, and family courts are very, very, what do you call them, rare. They're extremely rare. So if you see a jury trial in a family law case, 9 times out of 10, it's going to deal with some type of CPS element, termination, or something like that. They're usually very rare. So the process in which Meow Away Wolf is referring to is known as voir dire. Now, in some jurisdictions, they say voir dire, but here in Texas, I'm country, so I say voir dire. All right. So voir dire is a process where a series of questions is asked to potential jurors to see how they will respond, because it helps the attorneys determine whether or not that person would be good for whatever their side of the case is. So if you're trying to prove that the child is better off with one parent over the other one, you want to ask certain questions to see how the jury would respond to it. You're also you're also asking these questions to see if any of your jurors would potentially be biased against your clients, right? So if you have a father's rights advocate, for example, a father's rights advocate that is sitting in the jury box, and the person who wants custody is a father, the attorney that represents dad would want that father's rights person on their jury panel. Okay. The person who represents mom probably won't, because they're already going to assume that that father's right person is not only going to be in dad's favor, but they're going to taint the jury pool, meaning they're going to influence all the other jurors to see the case from their lens and rule in dad's favor. So that's what you're doing. So if you're able to point out certain biases, like somebody can't follow the law, absolutely cannot follow the law, you want that person struck for cause, right? They're biased. They're not going to follow the law. They do not need to serve on the jury panel. So that's what that is when they're asking those questions. They're asking those questions to get to know what their potential jury panel will look like, to see how these people would possibly rule in their, if they're going to rule in their client's favor or not. That's what voir dire is. Thank you for that question. Can a judge say things like, you had more training, answering my question as to why we having sympathy for the respondent? Judges say a lot of things. They say a lot of things. And unfortunately, depending on what they say, you really can't get them in trouble for it. Now, if they start saying things that are discriminatory, or it's clear that they are extremely biased over one person favoring one person over the other, like they say that explicitly, then you can do something further to request that you have a new judge, because they're not supposed to do things like that. Do women ever have to pay child support? Asked by Joseph Wilson. Absolutely. Women pay child support all the time. Most of my clients are men. I would say about a good 80 to 85 clients are men. There are a number of men who have custody of their kids. There are a number of women who pay child support. Okay. So, yes, the answer is yes. Kevin Dobbins, good afternoon, Queen. Good afternoon. Good afternoon to you, King. Thank you for being here. Okay. My name is Adrian. Sorry, I'm sorry, LOL. For example, it's okay, Adrian. If I pay $200 on health insurance for my boy and 500 of child support, and the mother of the child wants more money, how would it be appropriate to ask a judge? Well, let me just say this generally. You can go to court and ask for anything you want to. Now, will you get it? Chances are probably not. But can you go to court and ask for everything? Yes, you can. That does not mean you're going to get it, however. So if you're paying, usually the person who is the obligor, which means that person is ordered to pay child support, 9 times out of 10, that's also going to be the obligor of health insurance. Okay. If you're paying $200 in health insurance, one or two things is going on. You're either paying that $200 directly back to mom as a reimbursement for her coverage, or you're paying it directly out of your paycheck, which means if you're doing the latter and it's being paid directly out of your paycheck, you are receiving a health insurance credit on that already. Let's see, Kevin Dobbins. I live in Michigan and swap weeks with my ex-wife Friday to Friday. I pay the health insurance and I'm being told I have to pay $400 a month because I make more money and I have separate children. Normal. In Texas, that could be normal. That is an excellent question. That could be normal. Some people that split custody still have to pay child support because in determining, and just so you know, Kevin, in Texas, this is Texas law again. So in Texas, we have a list of factors. It's the Texas Family Code section 154.123. I'm giving you that so you can go and read about those factors so you can reach out to an attorney in your jurisdiction in Michigan and ask them, do they have something similar to that in Texas? Because if they do, they are able to direct you and show you exactly why you're in that position and having to pay child support on top of having a split schedule. That is very common and that can happen based on who makes more money. Thank you for your question. Maisha Freeman, are both parents unmarried required to pay child support if the child is with a grandparent? This is an excellent question, and I actually talked about this with the students today in Career Day. Absolutely. If a grandparent can prove that they are in possession of a child, have been in possession of a child, guess what? Both parents will have to pay child support to that grandparent. How much they'll pay, it really depends. If they don't work, it'll be set at minimum wage. If they work, it'll be based on their income. But yes, the answer is yes, they will have to pay child support to the grandparent. Thank you again, Ms. Freeman, for your question. Chloe Sade, how you doing? How you doing? Is it Yandale Avendano? How you doing? How are you? Um, Anthony, thank you for the super chat. Can pro se charge attorney's fees if malicious conduct is proven through res judicata and collateral estoppel codes, i.e., contempt? Thank you for this question, Anthony, and this is an excellent question. So attorneys fees can only be awarded to attorneys, right? So if a person is pro se, you're not going to be able to recoup on attorney's fees per se. However, if you are found to be held in contempt, the court can assess a fine to you as civil punishment. It's a civil contempt. On last time, we talked about the difference between criminal contempt and civil contempt very briefly because we're getting ready to transition into the enforcement. So you'll hear me talk about that a little bit more. And I will also let people know what you mean by res judicata and collateral estoppel. Because I'm pretty sure people were curious when they saw those words. So we'll definitely go over all of that. But yes, civil fine, yes. Attorney's fees, no, if they're not represented by an attorney. Thank you, Queen. Love you and thank you. Love you too, Kevin. Thank you so much for your question. Fire Flame, thank you for coming back. Fire Flame is always in the building, just like Precious Loves, not Mio, Away Wolf. They're always in the building. Thank you all for tuning in. In Texas, do the courts take the custodial parent pay for child support in consideration when making the payment or making the amount? Yes, depending on the situation. So if there is a situation where there is going to be a split custody situation, remember, split custody can be week on, week off, 2 days with one parent, 2 days with the other parent, rotate the weekends. There are variations on a split schedule, right? In those type of situations, the court can take both parents, the non-custodial parent and the custodial parent's income into consideration. Because if you're going to be splitting equal time, right, the court needs to know how far they're off in terms of income, because that determines what, if anything, someone is going to have to pay. The rationale, in my opinion, now this hasn't been anything I read, this is just what I can see from the practice of law. If a child is able to do all of these things with one parent, but not all of these things with the other parent, it kind of balances it out. So if one parent, the parent that makes less, let's say they make $30,000 a year, the other parent makes $200,000 a year. Well, obviously, the child is not going to be able to do as many things with the parent that makes less as they would with the parent that makes more. So to kind of balance that out, so the child doesn't really miss out on anything, like really big opportunities. Sit down, Zeus. Sorry, Zeus is back in here guarding me, y'all. So the child doesn't miss out on any opportunities. Some courts will make the parent who makes more money pay child support based on an offset. You all have seen some of the episodes I've done where there has been child support set based on an offset. So they take both child support amounts, subtract them, and the difference is what the parent who makes more will usually pay. Sit down. All right. Thank you, Fireflame, again for that question. Roxy Baby, advice on dealing with child support with other parent who claims self-employment. Oh, absolutely. When we cover child support, Roxy, we are going to talk about those who are employed with an employer and those who are self-employed, because you can get the income and I can tell you how to do it. You just have to be a little bit more creative, okay? And then if you represent yourself, it may take you more time, it may take you more energy. I know it will, but trust me, it can be done, okay? Thank you for that question. And please, Roxy, make sure you subscribe, stay tuned, because I would hate for you to miss out on that live session when I'm talking about that, okay? What if one parent moves to another country? How can you get child support if that parent earns a lot more money? This is an excellent question. Even if a parent moves to another country, if that withholding order is still in place, you'll still be able to recoup the money unless they start working for a foreign place or something like that. But some people move out of the country and their headquarters or HR department is still based in the United States. So you're still able to get money if that happens. If that does not happen and they're working for a company in another country, as long as that withholding order is there, they're still going to be accruing their back child support as well as interest. And at some point you will get it. It may not happen right away. It may not happen until your child is well into adulthood, but it's still there. So thank you for that question. Meow away wolf, are you hiring? LOL, I learn a lot more with you. No, I'm not hiring, actually. I'm very confident that I'm going to win my campaign in running for family court judge. So I will be winding up my firm when that happens. So I won't be hiring anymore. I'm done with the hiring process. But anyone who, if you, Meow Away Wolf, you are in the Dallas area. So if you would like to shadow me, you can definitely help me out on my campaign. I can be your mentor. So I'm shouting you out. You know, hit me up if that's something that you're interested in doing. Thank you, Kevin Dobbins. I appreciate that. Anthony, thank you, because I'm thinking pro say self represent themselves as lawyers, even though held to less standards than attorneys. And Anthony, I want to clear this up for you. People who are pro se are held to the same standard that lawyers are held to. That's the reason I'm doing this for you all, okay? Because you have to make sure you're prepared. If you're pro se and the other person uh, is represented by an attorney, you're held to the same standard as that attorney is. 9 times out of 10, you're not going to know as much as that attorney. They've had experience. They've taken what's called CLEs, continuing legal education courses. We know this information a lot better than you. So head on. If you don't know what you're doing, don't know what you're talking about, you're going to, and you may not be successful in your case. So I'm hoping that at least with this information is putting you in a better position to be able to represent yourself because you are held to that same standard. Okay. So good luck to you, Anthony, in your case that you have. Maisha Freeman, thank you so much. Thank you. Um, Meow Way Wolf, I would love that. Support you 100%. Thank you so much. Contact me by email. You can email me at Judge Vonda B at gmail.com. Matter of fact, I'll drop it in the chat here just so you can see it. Judge Vonda B at gmail.com. All right. Thank you. Let's see. I'm spending so much time and should be compensated. Anthony, if obviously I don't know your financial situation, but if you are able to hire an attorney for a limited representation is where it's one hearing or so you want them to represent you at. If you're able to do that, you may be able to recoup attorney's fees in that way in terms of your attorney getting paid, right? So that's an option for you. Attorneys are hired on limited basis. Christina, thank you so much. I really, really, really appreciate it. I really appreciate all of you participating in our super chat feature. And I hope that you all are getting a lot out of this. This is something I really, really am passionate about. Hi, how you doing? This is something I'm really passionate about, educating people about their rights, knowing what their rights are, knowing the law in general. There's a lawyer behind everything that you do. Everything. Okay. So the towel that you may use to wash your face or to dry yourself off, guess what? That brand who makes that towel, there's a lawyer behind it. This computer screen that I'm talking to you from, there's an attorney behind, I think this is Hewlett Packard. There's an attorney behind that. The glasses I have on, there's an attorney that represent lens crafters. This shirt, everything that you do, a lawyer is behind in it. Okay. It involves some legal aspect. Because it's that, you need to know your rights. Okay. You need to know. Let's see. Fireflame. How can you get that order if the other parent refuses for the parent to see the child? We want more days, but the other parent won't let me see the child, only ordered days. So in the Texas Family Code, it's made very clear that if you want to, assuming you're talking about a modification, Fireflame, if you want to modify a custody order, simply saying I want to see the child more is not a basis for a modification alone, right? If you have other reasons why your custody order or child support order, they're usually in the same document. If you have reasons that will trigger the material and substantial change reasons in Texas for needing a modification, go ahead and throw that in there. But that can't be the absolute only reason. Well, give me an example, Vonda. What do you mean by that? It's been 3 years. You work at a different job now. You're getting paid less though. That's a reason to ask the court to modify your child support so your child support can be reduced, right? So while you're already asking for that based on the modification, that's a legitimate reason to ask. Go ahead and throw in there, you're asking for more time with the child. If your child is age 12, guess what? That triggers the material and substantial change. If your child is under the age of 12, though, however, simply wanting more time is not going to be an only basis. But if you're already going to be in there for a legitimate reason, just go ahead and throw that in there and ask the court, what type of schedule you're looking for, and tell them why. Tell them why. Not just get away from just, okay, I want to have more time with the child. Look at the child's education, their report card. Are they failing in school? Are they being brought to school late? Let's say their first period of the day is math. Well, they're getting to school late every day and they're failing math. There's a direct correlation between them getting to school late and failing their first class of the day, right? So these are some of the things that you have to bring to the court's attention. Communication is huge. If the other parent is not talking to you, like co-parenting and everything like that, you're reaching out, she's not responding, that's another reason to ask the court to say, hey, can we have more of a split schedule? Because if your schedule is more split, it lessens the chances that you all have to talk to each other. When you're on a schedule that's not split, you have to talk to each other a lot more, right? But if your schedule is split, same rights, equal rights, one may have to pay child support, one may not have to pay child support. You all carry health insurance, you do everything independent, you're golden. So yeah, it can't hurt. If you have a legitimate reason to modify a court order, go ahead and ask for more time while you're at it. Okay. Kevin Dobbins, thank you again. Thank you again for the good job. I really appreciate it. For the super chat. Again, you guys can participate in our super chat feature. One more question. My current wife wants to move to Texas. I'm currently in Michigan, but my two youngest are 6 and 9. What's the best way of doing that split custody? Is it any way to split going to another state? This is an excellent question because people come to court and ask this question all the time. There's not a way to do split custody in other states. Not at those ages anyway. Primarily because they're 6 and 9, they're in school. They're in a curriculum that counts. So the only way that I could potentially see that happening is if they're doing some sort of homeschool thing that is virtual, 100%. Absent that, is not going to be a way to do a split schedule in different states, unfortunately. Thank you for your question, though, Kevin. Cindy Martinez, do you have consultations available? Yes, I do, actually. If you contact my office, you can schedule a consultation. My office number is 214 732 9429. I also dropped it in the chat. Call my office. They keep my calendar, so they'll let you know what days and times that I'm available to do a consultation. I am available for consultations. I just want to let you all know, though, if you call me for a consultation, consultations are not free. They're $325 for up to 1 hour. That's why these live sessions are so important. I'm giving you free information right here, right? So if it's something that you need, you may be able to get it from here. But if you don't get it from here with me being live and you have a little bit more and we need to talk for an hour, it's going to be $325. Okay. Do judges usually ask families to mediate or try to resolve child support during the first hearing? Thank you, Frank. This is a great question. Yes, they do. Yes, they do. In some counties in Texas, mediation is actually required before you have a temporary orders hearing. And if you all can't settle in mediation, then there is the necessity, right, of the hearing. But the objective is to get you to mediate first, work through those issues so you won't even need court intervention at all. Okay. How often can the custodial parent request for a modification? Once a year, 2 or plus years. Thank you, Meow Way Wolf. You can ask for a modification as necessary. So the rule is you ask for a modification when there has been both a material and substantial change. And there are certain scenarios that will qualify under material and substantial, right? So if under the court order, the other parent had possession of the child, well, custody of the child, and they gave the child to you, that's known as voluntary relinquishment, which means that that's a material and substantial change. This child no longer lives with this parent. They live with me. We need to get an order that changes that, and that other person needs to pay child support if that's what you're asking for. So you can get a modification as often as it's needed, as long as you meet that burden of material and substantial change. Okay. Thank you for your question. Christina, can a judge not make a mother pay half of medical bills if she claims she can't pay it? If she is being held in contempt, but she claims she can't pay, but hasn't submitted any documents, a judge can make a mother pay half of the medical bills, even if she claims she can't pay it. They can do what's called a judgment, a money judgment. So, whatever the amount is that she's found to be held in contempt and did not pay, they can make that a money judgment where, let's say, the money judgment is $5,000. So, that's a judgment that she has on her, and they will order her to pay it at a certain rate. If she does not do that, you can go back to court and ask the court to hold her in contempt again. And for child support in particular, you can be put in jail for it. So yes, the court can make you pay medical bills or even child support if you're claiming that you can't afford to pay it. There's never going to be an excuse that can get you out of paying medical support or child support. It's just not. Okay. Um, but where I'm from, child support and visitation are different courts. Okay, great. I'm fire flame. Thank you for pointing that out. In Texas, you have three types of courts if when you're talking about family court. So family court is one umbrella. You have the child support court. Child support court only deals with child support. So my show, Support Court with Judge Vonda B, is mirroring child support court. Okay. You have associate courts. Associate courts are the courts where your temporary orders hearings take place. That's a different judge from the child support court. Okay. Most hearings are going to take place in front of your associate judge. That's going to be the first judge that you always see. Then you have district courts. A district judge is completely different from these other two. And that's not in all counties. This is in Dallas County specifically. Some counties only have one court that addresses all of that. Then you have some counties that only have a district court and a district court only, or they may only have a child support court. It really depends on the court. But in Dallas County, there's three. So child support courts only deal with medical insurance, especially if Medicaid is at issue, and child support. They don't deal with custody at all. If you have a custody issue combined with a child support issue and you're in child support court, they will more than likely refer that case to the district court. Okay. So when it goes to an actual district court number, the first judge you will see is the associate judge. Okay. District judges, they hear the contempt actions, they hear the final trials, they preside over the jury trials. They have very limited things that they hear. Most hearings in Dallas County in particular will take place in front of your associate judge. Okay. They refuse to communicate. They feel they are the better parent. Fire flame, that is a good reason to go to court. Look at your court order. See what has changed since your court order has been in place. Make a note of it. Then go and read section 156 of the Texas Family Code. Chapter 156 of the Texas Family Code addresses the modification. And I'll be getting into the modification here soon. Read over that, and based on what has changed since your order has been in place, see what things you can ask the court to change about your order. Okay. And that is going to be one of the things that change, because in order to have a healthy child, in order for that child to thrive and you to do what's in their best interest, co-parenting must exist. Communication has to take place. It's a big deal. I believe Adrian, since I started paying child support, it was court ordered to change his last name, but having trouble getting it changed with the custodial parent. It has been 3 years. What can I do? Excellent question. If it has not been changed that long, you need to go back to court. You need to go back to court and let the court know. If it was court ordered, she is in violation of that court order. You gotta be willing to hold feet to the fire, especially guys. I had this conversation all the time with men. You cannot be passive aggressive when it comes to getting the mother to follow the court order. Hold her feet to the fire. If she is not following that court order, let that court know. Ask them to hold her in contempt. Okay. That's what you're going to have to do in order to make sure she follows the order and gets that child's name changed. 3 years is too long. What can I expect from a GAL? It's possible that my case will be appointed one. So just so you all know, I said GAL, that stands for guardian ad litem. A guardian ad litem in Texas is an attorney who is assigned to represent either in some cases it can be a parent, but in a lot of cases you'll see it with a child being represented by them, right? So that is somebody who is independent of the case. They're like an investigator, I guess you can say. Their scope is very, very focused. Okay, they're focused to do very, very limited things. The person that they are put on a case to appoint, that's the person whose interest that they are protecting. They usually give a report to the judge of the things that they have come across within their, I get the best way to explain it is within their investigation. Okay, but just so you know, it is an attorney. A guardian ad litem is an attorney represented to protect the interests of the child, if that's who they're representing, or an adult, if that's who they're representing. Thank you for that question, Chloe. Fireflame, this is our last question of today. That also is expensive for a non-custodial parent. It is very expensive. I definitely agree with you. Okay. Thank you, Chloe Sade. Thank you. You are very welcome. Thank you all again for tuning in. I have some exciting news for you because the last time we were on here, a lot of people were asking questions about the enforcement, holding somebody in contempt. We covered that. So guess what? We are done with the temporary orders hearing live session segments. We're moving into the enforcement. It's about to get real because you guys are about to find out how you can make sure that somebody follows their court order. I'm going to tell you how to prepare your motion. I'm going to tell you the specific language that needs to be in your motion. I'm going to tell you what you need to present in court to prove up your case. I'm also going to tell you what needs to be presented in your order that you present to the court. I'm going to give you all that information. Okay. So make sure you all are tuning in on next week so we can discuss the uh, enforcement. Okay. Now, next week, I recognize is Thanksgiving. All right. So I'm going to switch things up a bit. So instead of, we normally meet on Tuesday and Thursday, right? I'm going to switch things up a bit and I'm going to do the enforcement on Wednesday, the 24th. So Wednesday, the 24th, same time as Tuesday at 12 o'clock p.m. Central Standard Time. Again, make sure you all write that down. Next Wednesday, November the 24th, 12 o'clock p.m. Central Standard Time, we will be discussing the enforcements. We will be discussing the hearing. Tune in. You all take care. Have a great weekend. Be safe. And I will see you soon.